for property located at 219 Phyllis Lee Drive to allow for a photography venue and special events for weddings and other similar uses on the property. Immediately after the approval of that special exception, neighboring property owners filed suit against the board, alleging that the decision was arbitrary and capricious, to which the county responded with defensive pleadings, arguing that the decision was fairly debatable. That matter has since been non-suited. However, the neighboring property owners who were the plaintiffs in that matter have continued to come back to the Board of Supervisors requesting the board take action to revoke that special exception. Considering this revocation request, I think there are two competing interests here. One would be revocation authority that the county has, then would be the counter argument from the current property owners who have use of that special exception, in that they would probably claim they now have a vested right in using the property under those special exception conditions. Revocation procedures that are set out in the county ordinance requires that the board consider a revocation if there is a change in conditions affecting the public health, safety, and welfare since the adoption of the exception, or two, repeated violations of the zoning ordinance or any conditions, or three, fraudulent, false, or misleading information is provided. In evaluating the current status of the property use, I have been advised that there indeed was a violation at the very beginning of immediately following that May 2024 special exception being granted, in which the Fishers began holding wedding events and photography events prior to obtaining approval for their entrance from the Virginia Department of Transportation. That was a timing issue. VDOT has since approved their entrance, so that is no longer a concern. Additionally, there have been complaints of loud music, allegations made that this was misleading, that the Fishers misled the board because Ms. Fisher stood at the podium and indicated that she would only use a very small amplifier. Her promise to do that never actually made it into the conditions that were approved by the Board of Supervisors. So what was said, while it may have sounded like a promise, really means not much unless it was included as a condition of the special use. I want to turn to the opposing view of the Fishers claiming a possible vested right. Under section 15.22307 of the code, localities cannot impair a property owner's vested right to use their property if the landowner obtains or is the beneficiary of a significant affirmative governmental act which remains in effect, relies in good faith on that act, and incurs extensive obligations or substantial expense in diligent pursuit of the project. Now, under that code section, a significant affirmative governmental act is specifically defined as the granting of a special exception. Clearly, there has been an affirmative governmental act, and I believe that there is a good argument that can be made from the Fishers' perspective that they have relied in good faith on that special exception and have expended monies to further that end. My recommendation to you at this point that revocation not be considered, simply because I believe that the Fishers have a pretty good legal argument for a vested right. It really would not behoove the county to try and revoke and then have them bring us into court, have the court say they have a vested right, and they go back to using the property as under the special use conditions as provided.